It was May of last year when then U.S. Attorney General Jeff Sessions came to the border wall here in San Ysidro to announce the Department of Justice's new zero-tolerance policy.
If you cross the border unlawfully, then we will prosecute you. It's that simple.
Previously, the U.S. Attorney's Office had not made much of a priority of prosecuting misdemeanor illegal entry. By the time of Sessions' announcement, however, prosecutions for illegal entry had already begun to climb in the district, overwhelming the courts and nearby federal jails with people who had previously been quickly turned over to the custody of Immigration and Customs Enforcement. It was then that the chief judge in the district finally allowed for the creation of Operation Streamline, a fast-track prosecution program that aims to arraign, convict, and sentence border crossers in a matter of minutes. Starting last July, some people caught crossing the border illegally were brought here to a converted garage beneath the federal building where they met with their attorneys before being brought to a courtroom to plead guilty en masse to misdemeanor illegal entry. At first, prosecutors were charging upwards of 50 people a day. But last month, the Ninth Circuit ruled that almost all of the prosecutions during the first year of the program were improper. Prosecutors, the court found, had charged individuals under the wrong statute. Chuck Labella is a former U.S. attorney in the district who's now in private practice.
If you read the decision, you can see the pain and you can feel the pain of the judge saying, look, I sympathize with the prosecutors. I sympathize with what they're up against and what they're being asked to do. But you got to fly right. Just because we want to shove these people through the system, we don't cut corners in the criminal justice system. You just don't do that.
The mistake that prosecutors had made, according to the Ninth Circuit, was that they charged misdemeanor illegal entry under a subsection meant to only apply to people who elude inspection at ports of entry, not between them. The vast majority of people caught crossing the border do so by hopping over a border fence or crossing through the desert. The U.S. Attorney's Office did not respond to repeated requests for comment for this story. A source close to the office, however, tells KPBS that the decision to charge under the wrong law was made by prosecutors concerned about defendants arguing that, because they were being watched by Border Patrol agents when they crossed the border, they didn't actually elude inspection. Proving that a border crosser wasn't being watched generally requires Border Patrol agents and other officials to testify. Using the other section of the law, they wouldn't have to prove that. Ruben Camper-Khan was the executive director of the Federal Defenders of San Diego until shortly after Operation Streamline was installed in the district last summer. He believes this charging decision is one of the many ways prosecutors have tried to deprive immigrants of their right to a fair shot at justice.
If there's anything that would be more exemplary of a denial of due process than denying somebody a substantive defense that the law allows you, I can't think of it.
Carol Lamb is another former U.S. attorney in the Southern District of California. She says this type of decision is common for prosecutors who seek to undermine certain defenses, which might slow the process down when making a charging decision.
What you look for is the most efficient way to do as much as possible. You want to do things as efficiently as possible for your own prosecutors and for the agents, the ICE agents and the Border Patrol agents, so that they can not only do more cases, but they can do more sophisticated cases.
Over the past year, more than 4,000 people were charged improperly, according to the Ninth Circuit's decision. For over 400 immigrants convicted under the wrong subsection who are now appealing their cases, the charges can most likely be quickly dropped after a request by their lawyer. For the thousands who have not appealed their cases, the path ahead is much more complicated because they've already been deported. Today, Operation Streamline has slowed down considerably and operates at nowhere near the prosecution rates once envisioned by former Attorney General Jeff Sessions. But the impact of these decisions, by both officials in Washington and prosecutors in San Diego, will leave a mark on the U.S. Attorney's Office, says former Office Chief Labella.
It's a blemish on law enforcement when a court of appeals reverses saying you're using the wrong statute, and you're using the wrong statute because it's easier rather than it's the right statute. It's an embarrassment for law enforcement.
The U.S. Attorney's Office has until September 6th to appeal the Ninth Circuit's decision. Max Rivlin-Nadler, KPBS News.